What's up, y'all? This is In Your State and On Your Screen, your no bullshit guide to how your state is or isn't protecting your digital rights. After California set the bar with CCPA and CPRA, it really makes me hot and bothered. The next wave of states had a choice. They could either copy and paste or build something new. So let's talk about the states that chose differently, Colorado and Connecticut. Colorado, at first glance, it looks similar to California's law, but Colorado built theirs with a different focus. While California was centered on giving consumers immediate rights and transparency, Colorado's approach is more forward-looking. It's designed not just to protect people now, but to anticipate where data collection and technology are headed next. Colorado's law applies to businesses that process data from at least 100,000 consumers or sell data of 25,000 or more for profit. But more importantly, it reflects how data flows actually work today. It uses a controller processor model, which is how most modern platforms operate behind the scenes, especially those handling data through third-party vendors or ad networks. But the thing that makes Colorado stand out is what's called universal opt-out. Instead of putting the burden on you to click no 100 times a day, Colorado's law says your browser can send one single signal: don't track me. And companies are legally required to respect it. That's so badass. That changes the whole equation. It flips the default setting from surveillance first to privacy by default, which is exactly how it should be. And Colorado did not stop there, okay? By July 1st, 2025, companies are now required to adopt specific policies for how they handle biometric data, like facial recognition, fingerprint scans, and yes, even emerging neural data from brain-computer interfaces, which might sound far off and futuristic, but it's very real. Earlier this year, Colorado passed a law specifically classifying brain activity as sensitive data, making it one of the first states to legally recognize and protect mental privacy. And starting October 1st, Colorado is expanding protections for kids, requiring data impact assessments for any online service that targets users under 18. Next up, Connecticut. While Colorado is building for what's around the corner, Connecticut is showing how to enforce laws that we already have. Their privacy law took effect in 2023, giving residents the right to access, correct, delete, and opt out of the sale of their data. It also requires companies to present these rights clearly, so you can't hide behind complicated legalese. What sets Connecticut apart is how quickly it moved to hold companies accountable. In early 2024, the Connecticut Attorney General fined a ticketing company $85,000 for violating a privacy law, specifically for failing to respond to consumer complaints and skipping required compliance. That might not sound huge, but it's very symbolic. It tells companies that this law is not just ink on paper, it definitely has teeth, and we're paying attention. Colorado's building toward a future. Connecticut is showing up in the present. Two very different approaches, both proving that privacy isn't a lost cause. It's a fight that you can win if your state has the will to show up. Let's see who else is stepping up. See you next week.